In 1803, the Supreme Court ruled in the case Marbury versus Madison, and Chief Justice Marshall, in issuing his ruling, declared an act of Congress unconstitutional. And he said that the court has the power to do this because the court has the power to say what the law is. Now, this makes a lot of sense, right? The judicial branch is there to interpret the law and make sure the law is applied correctly. In addition, the Constitution does have the supremacy clause, which says that the Constitution is supreme above regular law, and of course, that federal law is then supreme above state law. So, if the Constitution says that the court is supposed to evaluate the law, and the Constitution says that the sort of top law is the Constitution itself, then it makes sense that the court has the power to say if a regular law violates the Constitution, and therefore to declare that regular law unconstitutional and to say it cannot be law. So this makes a lot of sense and it flows very logically from the Constitution. However, it is not explicitly in the Constitution. The Constitution never uses the term judicial review, nor does it explicitly state that the court has the power to declare acts of Congress, of the president, and of states unconstitutional. But it does make a lot of sense given the wording of the Constitution that this would be a power of the court, and no one has challenged it. In fact, people accept that this is what the court does and allow the court to rule things unconstitutional. Though, as you'll see on the slides or some other videos, there are ways around this for the so-called political branches. So Congress and the president can sort of get around the court's judicial review power if they really want to.